Hey everyone, this is Joe Concepcion coming at you from Lakeland, Florida. Criminal defense attorney. I call myself the Heartland Defender because I love this Heartland area of Florida. I'm still figuring out what to do with this TikTok thing and haven't come up with a new idea on the law, but I have figured out that you can reply to a comment with a video. And so there's a comment on my actual physical control video that tickled me, and I'd like to reply to that. Jimmy Dale Turner Sr. says, "It's all bullshit. It's in the name, driving. The rest is just bullshit." Okay, this isn't a call out, so it's not one of those videos. I'm here to say I feel you and you've been heard. I sympathize with you and anyone else that thinks that way. I'm sure there's lots of us defense attorneys that think the same way. But this ain't my cousin Vinny, and I can't go calling around. I can't go around calling bullshit. I have to do things in a slightly different way. As far as the law and whether we like it or not, like one of my favorite mentors used to say, I don't build these things, I just fly them. And likewise, I'm telling you what the law is, and I can tell you what I try to do with it. There's not a lot I can do to change the law as it is or to try to disregard it. In most cases, we start with every conceivable disadvantage, and this is one of those cases where it hurts even more that the legislature decided to throw an additional presumption at us. That just hurts. The deck is already stacked in the state's favor in most cases, and now we've got this to deal with. The client isn't actually driving, so they can convict him of driving on it. They can convict him of driving on an offense called driving when he's not actually driving. Like I said, that hurts. But as a defense attorney, I can't sit here and just say it's bullshit or say it hurts. I have to do something with that. So what do? We study the law. We find what the elements are. We press the state on that burden. In this particular case, with actual physical control, we may not like that doctrine, but it can certainly be used as a weapon. We can weaponize it by pointing out to the state that, look, there are cases where APC is clear, but not this one. Let's say the client wasn't even in the driver's seat, and the keys were in the trunk, and there's no conceivable argument that the person was driving, to try to get the state to dismiss that case before it even needs to go to trial and have a jury decide that it's all bullshit. So that's what being a defense attorney is. It's constantly starting with every possible disadvantage and sometimes having a couple of things thrown at us that we feel stack the deck against us a little more and that aren't fair. But we do what we can. We try to make lemonade out of those lemons that are thrown at us by the legislature, and we do what we can. If the circumstances are good for us, like an actual physical control, we can argue a combination of the facts or law, or facts and law, but in most cases, we're arguing the facts or the law. And like they say, if the facts aren't on your side, argue the law. And if the law isn't on your side, argue the facts. And if neither of those are on your side, we'll pound the table and yell like hell. But just don't say everything that guy said is bullshit. Keep watching for more of my random legal musings.